Welcome back. So there was due to some electricity cut off, due to electricity cut off, I lost my you can say, power outrage, which further resulted in the loss of network and connection with the WebEx Cisco. And hence, I lost my you can say there was a disturbance in the recording. So the remaining part I am recording it again. So the inconvenience caused is deeply regretted. Further, we have seen the case of in the last lecture, the last video, uh, the case of Venkat Subramania versus Ishwara. This was the case which we have seen, and we have seen that, however, whenever if the division of the property made by the father is unequal or fraudulent or initiated by a favoritism, a partition can be reopened. This was held in the case of Venkat Subramania versus Ishwara, which means that if the co-partners feels that there is apparent something which has been done and which is equivalent or fraud or cheated by favoritism, the partition can be reopened. Because there are chances, there are instances which we can see and we can feel that, but due to which the father can act nullified and the other co-partners are having the remedy. It is not that it is an absolute law. It can be challenged in the court of law. So this is what, with regards to the, we can say, the father is acting nullified, and therefore the father should act bona fide in good faith. He should be doing the things because all the family members, according to the law, according to the text and the scriptures, are equal and they are having an equal share. Therefore, the father should also treat them equally. He should not be biased or partial. And partition is a very important, you can say, division of the property because it, it has the co-partner has their share, which is given them by the nature. It is uh, thought so that whatever nature has been providing them, accordingly they have become eligible for their share. So this was what happened in the case of Venkat Subramania versus Iswara. Further, we will be seeing the case of Briraj versus Siodhan. In this particular case, the father cannot exercise his power by by will except with the consent of his sons. So in some of the cases, we are seeing that now whatever power has been provided to the father, whatever power has been given to the father for partition, there are certain limitations and exceptions. There are certain check and balances also which has been provided by judicial activism. And this is an old case, Raj versus Hughes in the year 1911. So in this case also it was held that the father cannot exercise his power, the power which has been provided or partition by will except with the consent of his sons. So there are certain things that if the father has been given the power, no doubt, but when the father is acting malified or father is trying to, what we can say, not he's not consenting the sons and he's trying to become a dictator. So dictator when he's trying to impose the things and in a very, we can say, nullified manner, in a fraudulent manner, he's somewhere having a biased attitude. That is a thing which has been checked by the judicial activism and the courts have provided. Because when the cases come to the courts are able to analyze what is the ground, what is the, we can say, the misuse of the law. And whenever there is a misuse of the law, the court tries to check it. The court tries to provide a correct interpretation of law. Okay, so no doubt the father has been provided that the father is having the right. The father has not merely a right to partition between himself and the sons, but also he has the power to effect the partition among the sons. This seems to be the last survival, we can say, of the father's absolute past. The Mitakshara, as we have discussed, explicitly confers the power of the father in respect of not only father's separate property, but also when we talk about in respect of joint family. And no other person has this power. In the exercise of this power, the consent or dissent of the sons in many cases is immaterial because the court also sees many grounds because there are grounds of legal necessity. There are different grounds which are there. And also, in many cases, we have seen, such as the case of Apura versus CIT, very first case which we started. The father can impose even a partition, partial or total, between his minor sons and himself. He is having these powers, but also he's having some check and balances. And those limitations are there which tries to check the father. If the father is trying to misuse the power, if the father is trying to act biasly, then what happens? The court interferes and the court tries to check and correct whatever rectification is required in the interpretation. Because as I told you, students, this is the basic thing which we have to understand, which we have to understand in your this particular, you can say, in your initial years itself, that the law is same. It depends upon the interpretation. And many times, what happens? The courts are there. They are working or they are pronouncing the judgment on the arguments, and the arguments are important. Okay, so we can say there is no one. You can say a particular criteria or particular rule by which we can paint all the bushes with the same brush. It is not so. You have to have different approaches in different cases which are having different facts. If it is proved that the father has done something intentionally and with a biased intention or with a fraudulent intention, because it may happen. We are a student of law, we know that neither we can, as a as a student of law, neither we can say that the father is culprit or the sons are culprit because the statue of law is blind. It is having, we can say, black ribbon on her eyes, and therefore she is not able to distinguish. She is only able to distinguish on the basis of the facts. Okay, so an unequal partition made by the father may be binding on sons as family arrangement if it in by them, if it is accounted by them, if it is done by them, and so, okay, if the sons accept. So these are the basic grounds which we have seen, and rather we have started the last class in which we have tried to see persons entitled to ask for partition. So there are few persons who are entitled for partition, and the very first is the father, which we have seen, and we all know that this particular arrangement which we have seen are having certain exceptions, and those exceptions we have already discussed that an unqualified co-pastor has no legal right to partition. This was the rule, and which has been further, we can say, challenged after the Amendment Act of 2005, and now the co-pastors have a right to ask for a partition. I'm talking about the daughters. Okay, so this was a general rule which was there, and in the latter is joined with his own father or collateral. Another qualification of the general rule recognized under Mitakshara jurisdiction is that the father's right to partition is superior to the right of partition of all others. Okay, the father's right is superior to the right of all others, and the father cannot only effect the partition between himself and his sons, but he can also impose a partition on his sons. So the Dakshara school is quite, we can say, if I have to criticize, it is male oriented or father oriented, or we can say some sort of karta oriented, because the Dakshara school is quite traditional and it has its own premises by which it tries to judges between the position of the father or karta. Okay. Also, earlier the daughters were unqualified because of the Mitakshara. Whereas when we see Dayabhaga school, in when we talk about the term the father's role in partition, so many of the rules are not acceptable by the Dayabhaga school, because the Dayabhaga school father is the absolute owner of the property and the question of partition during his lifetime does not arise. But if he is willing, if he wants to distribute the property, he can do so by his own will. So these are the basic differences which are from the very beginning we are discussing. And the important thing which we have to note is that these differences are reflected in we can say with different we can say perspective and different dimensions. If you talk about alienation, if you talk about adoption, if you talk about partition, if you talk about union, if you talk about succession. So that is the premises, and from where the jurist, the court has tried to infer and try to draw a conclusion. So, dear students, this is today. This is for today. In the next class, we shall start the grandson and great grandson. Okay, how they are liable and what are their powers and how they may get a share in partition. Okay, because I suppose 45 minutes have been over and there is a demand which is coming from the students to curtail the length of the lecture because according to them it is going a bit longer. So we will try to make it 45 minutes. I hope that it will be in your convenience. And I told you, I need your feedback regarding the length of the lecture. If people feel that we should continue for 50 minutes, I am having no issue. We may continue for 50 minutes. Okay. So have your time. Thank you.